The judge leaned forward and stared directly at the woman who had spent 6 months telling me I didn't belong on my own land. "Mrs. Whitmore," he said, "where is your deed?" The courtroom went completely silent. Across the aisle, Vanessa Whitmore, president of the Silver Creek Homeowners Association, stopped turning pages in the thick binder resting on her table. Her attorney, Richard Bell, slowly removed his glasses. Vanessa blinked. "Your Honor?" Judge Samuel Hayes didn't move. "You've testified that Mr. Daniel Mercer owes your association $42,000 in assessments, penalties, legal fees, and enforcement costs." "Yes." "You've also demanded that he vacate his property if he refuses to pay." "That is correct." The judge tapped one finger against the document in front of him. "Then show me the instrument establishing your association's legal interest in his land." Vanessa glanced at Richard. He leaned toward her and whispered something. I couldn't hear the words, but I saw the color leave her face. My attorney, Rachel Bennett, sat perfectly still beside me. She didn't smile. She didn't need to. Judge Hayes waited. Finally, Richard stood. "Your Honor, the association's position is based on the recorded declaration governing the Silver Creek development." "I've read the declaration." The judge's voice hardened. "I'm asking about Mr. Mercer's property." Richard swallowed. "The association maintains that his parcel falls within the community boundaries." "That's not what I asked." The judge turned toward Vanessa again. "Where is your deed?" Vanessa's fingers tightened around her pen. "We don't have a deed to his property." A murmur rolled through the courtroom. Several Silver Creek homeowners sitting behind her began whispering. Judge Hayes raised his hand. "Quiet." Then he looked back at Vanessa. "Do you have an easement?" "No." "A signed annexation agreement?" Vanessa hesitated. "No." "A covenant executed by Mr. Mercer or a previous owner voluntarily submitting this parcel to your association?" Her mouth opened. Nothing came out. The judge leaned back. "So let me understand this." His voice was calm now. Almost dangerously calm. "You demanded money from a property owner whose land you cannot presently demonstrate belongs to your association." Richard stood again. "Your Honor, there are additional circumstances." "I haven't finished." He sat down. My pulse hammered against my ribs. 6 months earlier, Vanessa had stood at the end of my driveway with 2 HOA security officers and told me almost the exact opposite. "Pay what you owe," she'd said, "or start packing." When I laughed, she handed me a notice, claiming the HOA had the authority to place a lien against my home. 3 weeks later, they filed one. Then came the collection letters, the fines, the attorney threats, the security patrols photographing my house, and finally, a lawsuit asking the court to authorize foreclosure. They weren't trying to scare me anymore. They were trying to take the property my grandfather had bought outside Cedar Ridge, Colorado, in 1968. But Vanessa had made one mistake. She assumed I would panic before I started digging. Rachel slid a yellow folder across our table. "Your Honor," she said, "I believe this will answer the question Mrs. Whitmore cannot." Vanessa turned toward us. For the first time since this nightmare began, I saw genuine fear in her eyes. Richard immediately stood. "Objection. We haven't authenticated whatever counsel is attempting to introduce." Rachel didn't even look at him. "We can authenticate it." Judge Hayes studied her. "What exactly is in that folder, Ms. Bennett?" Rachel placed her hand on it. "A certified county record from 1994, Your Honor." Vanessa's chair creaked as she shifted backward. Rachel continued, "And once the court sees it, I believe we'll understand exactly why Silver Creek HOA has been pretending to own authority over Mr. Mercer's land." The judge held out his hand. "Bring it forward." And that was the moment Vanessa whispered something I was never supposed to hear. Oh God. Because she knew exactly what was inside. 6 months before that courtroom fell silent, I was living a life that would have bored Vanessa Whitmore to death. My name is Daniel Mercer. I was 56 years old, and I made my living restoring historic homes around Cedar Ridge, Colorado. I wasn't wealthy, politically connected, or interested in neighborhood politics. Give me old timber, a damaged foundation, and enough coffee, and I was perfectly happy. My own house sat on 11 acres at the end of Mercer Lane. My grandfather, Walter Mercer, bought the property in 1968, when most of the surrounding land was pasture and pine forest. He built the original house with my father, and when I inherited it, I restored it without changing its character. The porch still had the marks where my father measured my height as a kid. The cottonwood beside the workshop still held the rusted hook from the tire swing my grandfather made for me. Selling wasn't something I considered. Then Silver Creek arrived. A developer bought nearly 200 acres bordering my eastern property line and turned it into a polished subdivision of stone entrances, landscaped sidewalks, and identical mailboxes. I didn't mind. Their property was theirs. Mine was mine. For several years we coexisted without trouble. Then one Tuesday morning, I walked down my driveway and found a white envelope taped to my mailbox. Silver Creek Homeowners Association. Notice of delinquent assessments. I actually laughed. According to the letter, I owed $3,840. I called the number at the bottom. A woman answered, Silver Creek HOA. I think you've sent a notice to the wrong address. She asked for my name. Daniel Mercer. There was a pause. Oh, yes. Mercer Lane. That's not part of Silver Creek. Another pause. Then she said, according to our records, it is. I looked through my kitchen window toward the old barn. No, ma'am. According to my deed, it isn't. She suggested I attend the next board meeting. Instead, I mailed them a copy of my deed with a short letter explaining the mistake. 2 weeks passed. Then another envelope appeared. This one wasn't taped to my mailbox. It had been certified. The amount had increased to $4,275. There were late penalties now, administrative fees, and one sentence printed in bold near the bottom. Continued non-payment may result in a lien against the property. I read that line 3 times. Then I noticed something else. Someone had written a note by hand beneath my address. Owner refuses compliance. Begin enforcement. That didn't look like a billing mistake. I carried the letter inside, opened the drawer where I kept my property records, and pulled out the deed my grandfather had handed to my father decades earlier. For the first time in years, I read every line. Nothing mentioned Silver Creek. Nothing mentioned an HOA. But when I looked outside again, a dark SUV was parked across the road. A woman behind the wheel was holding up her phone, and she was photographing my house. I walked down the driveway before the SUV could leave. The woman lowered her phone but didn't put it away. She was probably in her early 50s, dressed in a cream blazer that looked absurdly expensive for someone sitting beside a dusty county road. Her dark hair was pulled back tightly, and oversized sunglasses covered half her face. Can I help you? She lowered the window. Daniel Mercer, you're parked outside my property taking pictures. You already know who I am. She removed her sunglasses. Vanessa Whitmore, president of the Silver Creek Homeowners Association. That explained the confidence. What are you photographing? Exterior violations. I looked back at my house. What violations? Vanessa stepped out carrying a leather folder. Your detached workshop doesn't comply with Silver Creek architectural standards. Your fencing isn't approved. You have an unregistered utility trailer visible from the road, and your mailbox doesn't conform to community specifications. For a second, I honestly thought she was joking. My house isn't in your community. Vanessa smiled. Not warmly, patiently. Like I was a child refusing to understand simple arithmetic. Mr. Mercer, we've already explained this. No, your office sent me bills. That's not an explanation. She opened the folder and handed me several pages. The top sheet showed a map of Silver Creek. A thick blue boundary line curved around the subdivision, and somehow, impossibly, it wrapped around my 11 acres. I stared at it. Who drew this? Our management company uses county records. This isn't a county survey. It reflects the association boundaries. According to whom? Her smile disappeared. According to the governing documents. I handed it back. Then your governing documents are wrong. Vanessa closed the folder. You owe $4,275. If you continue refusing payment, additional enforcement costs will be assessed. You're threatening a lien on land you don't own. The HOA doesn't need to own your house. It needs legal authority over it. Her jaw tightened. Pay what you owe, Mr. Mercer, or start packing. I laughed once. I shouldn't have. Her expression changed instantly. You think this is funny? I think you standing on a public road threatening to take my grandfather's property because you drew a blue line around it is ridiculous. Vanessa stepped closer. You'll receive formal notice. She got into her SUV and drove away. Formal notice arrived 9 days later. The HOA had added architectural fines, legal review fees, and something called a non-compliance assessment. My supposed debt was now $6,940. Then things became stranger. An HOA security vehicle began driving past my house twice a day. One guard photographed my workshop. Another walked 15 feet onto my driveway before I confronted him. This is private property. We're documenting violations. From my driveway, we were instructed that this parcel is within HOA jurisdiction. Get off my land. He hesitated. I pulled out my phone. Now. He left. The following Friday, I took my deed, tax records, and the HOA map to the county recorder's office. A clerk named Margaret Ellis spent nearly 40 minutes searching the database. Finally, she turned her monitor toward me. Your parcel predates Silver Creek by decades, I know. And I don't see any recorded HOA covenant attached to your deed, so they're wrong. Margaret frowned. I didn't say that yet. She opened another record. This was filed 4 years ago. A document appeared bearing the Silver Creek HOA name. Attached to it was a legal description containing my parcel number. My stomach tightened. What is that? An amendment to the association declaration. Who authorized it? Margaret scrolled downward. Then she stopped. At the bottom was a signature line. Daniel Mercer, property owner. For several seconds I couldn't speak. Margaret looked at me. Mr. Mercer. I leaned closer to the screen. The signature looked vaguely like mine, but I had never signed that document. Print everything, I said. Her expression changed. You're saying that's not your signature? I stared at my own name beneath a document I'd never seen before. No. And suddenly, this wasn't an HOA making a boundary mistake. Someone had manufactured the authority they were using against me. I called Rachel Bennett from the county parking lot. Rachel was a property attorney in Denver I'd worked with twice on historic restoration disputes. She wasn't dramatic. She didn't make promises she couldn't keep. The first time I'd met her, she'd spent 20 minutes correcting another lawyer's interpretation of an easement without raising her voice once. When she answered, I said, "Someone forged my signature." Silence. Then her tone changed. Don't confront anyone. Don't call the HOA. Photograph what you have, then bring everything to my office. 2 hours later, the county records were spread across her conference table. Rachel examined the 2022 amendment with a magnifying glass. Did you know this notary? I read the name. Patricia Cole. No. Did you sign anything related to Silver Creek in April 2022? No. Were you even in Colorado? That question stopped me. I opened my phone and searched old photographs. Then I remembered. My sister had surgery in Oregon. I stayed with her almost 3 weeks. Rachel looked up. What dates? I checked. April 7th through the 26th. She tapped the document. This was supposedly notarized here on April 18th. Neither of us spoke. Rachel immediately requested the complete recording packet. Then she called a licensed surveyor named Thomas Reed. Thomas met us at my property 2 days later, carrying old plats, a GPS receiver, and the kind of patience that comes from spending 30 years arguing with boundary markers. He walked my eastern line for nearly 3 hours. Near sunset, he drove an orange stake into the ground. Silver Creek begins 37 feet east of here. I looked toward the nearest subdivision fence, so my land was never inside it. Thomas shook his head. Not according to the original subdivision plat, your deed, or the county survey. Rachel crossed her arms. Could the HOA legally annex Daniel's parcel later? Sure. My stomach tightened. Thomas continued, with his consent. Rachel looked at me. Which brings us back to the signature. Over the next 3 weeks, we started pulling threads, and every thread made things worse. Rachel discovered that the HOA's 2022 amendment hadn't only added my parcel number, it also changed language describing Silver Creek's western boundary. Thomas compared the legal descriptions. Someone had replaced an old survey reference with a newer meets and bounds description that curved conveniently around my property. Then Margaret Ellis called from the recorder's office. You need to come back. When Rachel and I arrived, Margaret had the original scanned filing packet open. There were 6 pages recorded, she said. But look at the page numbers. 1, 2, 3, then 5, 6, 7. Page 4 was missing. Rachel leaned toward the screen. Was it missing when recorded? I checked the archived intake scan. Margaret opened another file. 7 pages appeared. The missing 4th page contained a signature authorization from the HOA board. At the bottom were 3 names. Vanessa Whitmore, Richard Bell, and Calvin Ross, the developer who had built Silver Creek. Rachel stared at it. Why isn't this page in the public version? Margaret shook her head. I don't know. That evening, Rachel requested the original notary journal entry from Patricia Cole. Patricia called us herself the next morning. Her voice sounded nervous. "I've checked every entry from April 2022. Rachel put the call on speaker. "Did you notarize Daniel Mercer's signature?" "No." I gripped the edge of Rachel's desk. "Are you certain?" "Absolutely. And there's another problem." "What problem?" Patricia inhaled slowly. "The commission number on that document is mine." Rachel's eyes narrowed. "But the stamp isn't." She emailed us a photograph of her genuine seal. Rachel placed it beside the seal on the HOA amendment. At first, they looked identical. Then Thomas, who was still in the office reviewing surveys, pointed at the expiration date. The forged seal expired in 2026. Patricia's real commission had expired in 2024. Rachel sat back. "Someone recreated her stamp." My phone buzzed. An email from Silver Creek HOA. Final demand before foreclosure action. The amount they claimed I owed had jumped to $18,760. Rachel read it. Then she looked at the forged document. "They're accelerating." "Why?" She closed the laptop. "Because I'm starting to think your 11 acres aren't the real prize." She pulled Thomas's survey toward her and pointed at the western edge of Silver Creek. A proposed county road expansion stopped directly against my property. If my land became HOA controlled, Silver Creek could connect its subdivision to the highway. Thomas stared at the map. That access would be worth millions to the developer. Rachel's phone rang. It was Margaret again. Rachel answered. Margaret didn't even say hello. "I found something from 1994. Rachel went still. "What?" "A recorded agreement involving Daniel's grandfather, the previous owner of the land Silver Creek was later built on, and the county." She paused. "And I think it proves they knew from the beginning that Daniel's property could never be included in their development without his explicit consent." The 1994 document was only 6 pages long. It nearly destroyed Silver Creek. Rachel and I met Margaret at the recorder's office before opening hours the next morning. She led us into a records room and placed a certified copy on the table. Across the top, Boundary and Access Agreement, Mercer, Hollow Creek Development Corporation. My grandfather's signature was on page 6. This one I recognized immediately. Walter Mercer wrote his M like 2 sharp mountain peaks. Rachel read silently for several minutes before tapping paragraph 11. "Daniel, read this." The language was dense, but the meaning wasn't. My grandfather had granted the neighboring developer a temporary construction easement in 1994. In return, the developer permanently acknowledged that the Mercer parcel remained independent and could not be incorporated into any future subdivision, covenant system, or homeowners association without written consent from the Mercer owner. The agreement was binding on successors. Silver Creek's developer had purchased the neighboring property subject to that agreement. Thomas arrived 20 minutes later and confirmed the description. "This is your parcel. All 11 acres. Every inch." Rachel exhaled. "So they didn't accidentally overlook an old boundary?" "No," Thomas said. "Anyone doing title work for the development would have found this." Rachel requested Silver Creek's original title report. 3 days later, we got it through Discovery, connected to the HOA's lien action. There it was. 1994, Mercer Boundary and Access Agreement, listed clearly as an exception. Rachel looked at me across her desk. They knew. That was the smoking gun. The HOA had access to a title report explicitly warning that my property was outside its authority. Yet someone later filed an amendment, carrying my forged signature and a counterfeit notary seal. Rachel sent Richard Bell a preservation notice demanding that Silver Creek retain emails, board minutes, invoices, recordings, and communications involving my parcel. 48 hours later, Vanessa came to my house, not alone. 2 HOA security vehicles followed her up Mercer Lane. I stepped onto the porch with my phone recording. "You need to leave." Vanessa held up a document. "You've been served." A man beside her approached and handed me a lawsuit. Silver Creek was seeking foreclosure based on a lien that had now ballooned to $42,310. I stared at the number. "You added $23,000 in 3 weeks. Legal expenses," Vanessa said, "for defending your forged paperwork." Her expression flickered. "Be very careful with accusations like that. I'm not accusing you of anything. I'm asking why my signature appears on a document I never signed." One security guard looked toward Vanessa. She stepped closer. "You've had every opportunity to resolve this privately." "You mean pay you?" "I mean comply. With an HOA, my grandfather specifically refused to join." That landed. Her eyes narrowed. "You've been digging through records?" "Yes. Vanessa's voice dropped. You don't understand what you're interfering with. Then explain it. The community has long-term infrastructure requirements. My property isn't community infrastructure. You're one man sitting on 11 acres blocking improvements that benefit hundreds of families. There it was. Not covenants. Not neighborhood standards. Access. You need my land for the highway connection. Vanessa said nothing. I smiled without humor. That's what this has always been about. She turned toward her SUV. Pay what you owe or move out, Daniel. Those are your choices now. No. She stopped. You don't dictate my choices on my property. For the first time, her composure cracked. We'll see what the court says. After they left, Rachel came over. We sat at my kitchen table until nearly midnight organizing exhibits. The 1968 deed, the 1994 agreement, the original Silver Creek plat, Thomas's survey, my Oregon travel records, Patricia Cole's notary journal, the counterfeit seal, and finally, Silver Creek's own title report, proving they knew about the restriction. Rachel closed the last binder. They filed for foreclosure because they expected you to settle before anyone examined how they created jurisdiction. What happens when the judge examines it? She looked toward the stack of evidence. That depends on how many lies they're willing to tell under oath. Outside, headlights moved slowly past my house. Another Silver Creek security patrol. I watched it disappear down the road. For months, they'd tried to make me feel like a trespasser in my own home. Now they wanted a courtroom. Fine. We were ready to give them one. The foreclosure hearing began at 9 o'clock on a cold Monday morning. Vanessa arrived 20 minutes early. She wore a navy suit and carried the same leather folder I'd seen the first day she photographed my house. Richard Bell walked beside her with two assistants, pushing boxes of documents. Rachel leaned toward me. Don't react to anything. I'll try. No, don't try. I looked at her. She raised an eyebrow. Daniel. Fine. Judge Samuel Hayes entered at exactly 9. Everyone stood. Richard presented Silver Creek's case first. His argument sounded simple. The HOA's 2022 amendment included my parcel. I had supposedly consented to annexation. I hadn't paid assessments. Therefore, the association claimed its lien was valid, and foreclosure was an available remedy. Then Vanessa testified. Richard approached her. Did Silver Creek invent these assessments specifically to target Mr. Mercer? Absolutely not. Was he treated differently from other homeowners? No. Did the association believe his property was legally subject to its declaration? Yes. Rachel wrote something on her legal pad. When cross-examination began, she carried one sheet of paper to the lectern. Mrs. Whitmore, when did you first become aware of the 1994 Mercer Boundary and Access Agreement? Vanessa paused. I don't recall. Rachel placed Silver Creek's original title report on the evidence monitor. Would this refresh your memory? Vanessa looked at it. Richard stood. Objection. Lack of foundation. Overruled. Rachel enlarged the relevant section. Your developer's title report lists the Mercer agreement as an exception, correct? Vanessa shifted. That's what it says. And you reviewed this title report. I reviewed many documents. Rachel displayed an email. From Vanessa Whitmore to Calvin Ross. Subject, Western Access. The date was 3 months before the disputed amendment. Rachel read one sentence. The Mercer restriction remains our biggest obstacle to Western Access. Did you write that? Vanessa stared at the screen. Yes. A murmur moved through the gallery. Rachel waited. So 3 months before an amendment supposedly signed by Daniel Mercer, you already knew his recorded property agreement prevented Silver Creek from controlling his land. We believed circumstances had changed. What circumstances? We were told Mr. Mercer had reconsidered. By whom? Vanessa glanced toward Richard. Calvin Ross. Rachel returned to our table. Let's talk about Mr. Mercer's signature. Patricia Cole testified next. She brought her original notary journal. No Daniel Mercer appears anywhere on April 18, 2022. She told the court. Rachel displayed the disputed seal beside Patricia's genuine seal. Did you apply the seal on the left? No. Is that your signature? No. Did you ever meet Daniel Mercer? Not before today. Richard tried to suggest clerical error. Patricia stared at him. A clerical error doesn't manufacture my signature. Even Judge Hayes looked up at that. Then Rachel called Thomas Reed. He walked the court through the original plat, my deed, the 1994 agreement, and his survey. Is there any surveying basis for claiming the Mercer parcel was originally part of Silver Creek? Rachel asked. No. Could it be annexed? With the owner's valid consent. And absent that? No. Finally, I testified. Rachel asked where I was when the amendment was supposedly signed. Oregon. We introduced airline receipts, credit card transactions, and photographs from my sister's home dated April 18th. Richard approached me on cross-examination. Mr. Mercer, isn't it possible you signed paperwork before traveling? No. Perhaps you forgot? I restore historic properties for a living. I read deeds, easements, and contracts regularly. I wouldn't forget giving an HOA control over my home. His mouth tightened. You clearly dislike Silver Creek. I didn't care about Silver Creek until Silver Creek tried to foreclose on me. Someone in the gallery coughed to hide a laugh. Then Rachel stood again. One final issue, Your Honor. She handed the clerk the certified 1994 agreement. Judge Hayes read it. Then he reviewed Silver Creek's title report. Then Vanessa's email. His expression changed. He turned toward her. Mrs. Whitmore, your association seeks authority to sell this man's home. Yes, Your Honor. Then let's make this extremely simple. He leaned forward. Where is your deed? Vanessa froze. We don't have a deed to his property. An easement? No. A valid annexation agreement. Silence. Judge Hayes looked over his glasses. Do you even own this land? No. Rachel slid a yellow folder toward the edge of our table. Your Honor, I believe this will answer the remaining question. Richard immediately stood. Objection. The judge held out his hand. Bring it forward. Inside was the certified county record Margaret had uncovered after our evidence deadline. A record showing exactly who requested the altered 2022 filing. Vanessa saw the document number. Her face drained white, and under her breath, barely loud enough for me to hear, she whispered, "Oh God." The yellow folder contained something Rachel hadn't expected to find until Margaret called 2 days before the hearing. A county recording intake affidavit. It identified the person who had personally submitted the 2022 amendment that supposedly carried my signature. Vanessa Whitmore. Attached was a scanned driver's license used to verify the submitter. Hers. Richard Bell stood immediately. Your Honor, we object to the admission of this document. It was disclosed after— I understand when it was disclosed, Judge Hayes said. Counsel has represented that it was produced by the county after the deadline. Sit down. Richard hesitated. Your Honor. Sit. He did. Rachel authenticated the record through a certification from the recorder's office, then returned to the lectern. Mrs. Whitmore, you testified that Calvin Ross told you Daniel Mercer had reconsidered joining Silver Creek. Yes. You also testified that you relied upon that representation. Yes. Rachel pointed toward the screen. Then why were you the person who delivered the disputed amendment to the county? Vanessa's lips parted. Because Calvin asked me to. Did you watch Daniel sign it? No. Did you speak to Daniel before recording it? No. Did you contact Patricia Cole to verify her notarization? No. Rachel let the silence stretch. You knew the 1994 agreement prohibited annexation without Daniel's consent. Vanessa shifted in her chair. Yes. You knew Silver Creek wanted Western Highway access. Yes. You personally filed a document supposedly providing the consent you needed. I believed it was legitimate, and after Daniel told you repeatedly that he'd never signed it, you continued assessing fines. Vanessa's voice became quieter. I relied on counsel. Richard's head snapped toward her. That was the moment their united front collapsed. Judge Hayes recessed for 40 minutes. When he returned, nobody whispered. He spent nearly 15 minutes reviewing his findings. The 1994 agreement was valid. My parcel had never been part of Silver Creek. The HOA had failed to establish any lawful covenant authority over my property. The purported 2022 annexation document contained a signature I credibly denied making, and a notarization the named notary denied performing. Then came the words I'd been waiting 6 months to hear. The association's lien is void. I closed my eyes. Beside me, Rachel touched my shoulder. Judge Hayes continued, the foreclosure request is denied with prejudice. Behind us, someone whispered, Jesus. But the judge wasn't finished. He ordered Silver Creek to release every recorded claim against my property and prohibited the HOA from attempting further assessments or enforcement against my parcel. Then he addressed the attorney fees. Mr. Mercer should not have been required to spend substantial resources defending ownership rights the association could have verified through its own title records. He ordered a separate hearing to determine my recoverable legal costs and damages, and then he turned toward Vanessa. The evidence presented concerning the disputed signature and notarization raises issues beyond the civil matters before this court. Her face tightened. I am directing the clerk to transmit the relevant exhibits to the district attorney and the appropriate state regulatory authorities. Vanessa stared straight ahead. No smile. No leather folder held proudly against her chest. Nothing. The fallout moved quickly. Within 3 weeks, Vanessa resigned as HOA president. Silver Creek suspended its management company pending an internal audit. Homeowners demanded access to board records, and several discovered special assessments connected to the proposed Western Road project they'd never been fully told about. Calvin Ross's development company publicly withdrew the highway access proposal. The criminal questions surrounding the 2022 filing became a separate investigation, so Rachel warned me not to speculate publicly about who physically created the forged signature or counterfeit seal. I didn't need to. I had my land. 2 months later, I stood beside my mailbox while a county employee confirmed the final lien release filing. He handed me the stamped copy. Clean title. I looked toward my house, the workshop, the cottonwood, the porch where 3 generations of Mercers had sat watching Colorado sunsets. For 6 months, strangers had reduced all of it to parcel numbers, assessments, and development access. But standing there with that stamped release in my hand, it became mine again in a way I'd never appreciated before. Rachel smiled. You keeping that somewhere safe? I folded the document carefully, right beside the deed. Then I looked across the road toward Silver Creek. For the first time in months, there wasn't an HOA security vehicle watching me, just silence, and it felt incredible. A year later, Mercer Lane looks almost exactly the way it did before Silver Creek ever decided my property belonged to them. That's probably my favorite part of this entire story. No security vehicles crawl past my driveway. No certified envelopes appear in my mailbox demanding thousands of dollars. No strangers stand outside photographing my workshop and calling it a violation. Most mornings, I make coffee before sunrise and sit on the porch my grandfather built, watching the light move across those 11 acres. The land didn't change. I did. Before all of this, I treated deeds, surveys, title records, and old agreements like paperwork you locked in a cabinet and forgot about. Now I understand something different. Property rights don't protect themselves. Documents matter. Records matter. And when somebody with an official-looking letterhead tells you they have authority over your home, that doesn't automatically make it true. Rachel once told me the most dangerous part of the Silver Creek situation wasn't the first bill they sent. It was how confidently they sent it. Every notice looked official. Every threat sounded certain. Every person they sent to my property behaved as though the argument had already been settled. They were counting on that confidence to become my reality. It almost did. I still keep the certified copy of the 1994 agreement beside my grandfather's original deed. Sometimes I look at his signature and wonder whether he ever imagined that decision would protect his grandson decades later. Probably not. He was just protecting what belonged to his family. And in the end, that's exactly what I had to do too. If there's one thing I hope you take from my story, it's this. Never confuse someone's confidence with their legal authority. Ask questions. Read the documents. Keep records. And when something doesn't make sense, don't be intimidated into surrendering before you understand the truth. If you've ever dealt with an HOA that crossed the line, tried to enforce rules against property it didn't control, or threatened you with fines you believed were unfair, tell me what happened in the comments. And here's the question I really want to ask. What would you have done the moment Vanessa told you, pay up or move out? If you enjoyed this story, hit like, subscribe, and turn on notifications for more stories about property disputes, impossible neighbors, HOA battles, and ordinary homeowners who finally decide they've had enough. Thanks for spending your time with me. And remember, sometimes the most powerful question in the entire courtroom is also the simplest. Do you even own this land?